Good afternoon. We're on the record in the matter of the San Diego Police Department versus LM. Let me get appearances for the record, please.
Good afternoon, Your Honor. Jeff Brooker on behalf of the San Diego Police Department.
Good afternoon, Your Honor. Bonita Martinez on behalf of the respondent.
Good afternoon, Matthew Holger and Shepard Mullen Richter in Hampton on behalf of KFMB.
Thank you. Good afternoon to everyone. And just so you know, the proceeding is going forward via Microsoft Teams with the computer in the courtroom. I have signed a request by the media to film. Given that you're all appearing on Microsoft Teams, I am allowing the recording also from Teams because that's the only way all of you are appearing in the courtroom. Given that these proceedings have previously been reported, again, I signed the request without a hearing and have authorized the filming. I don't know if you could see or not that there is a camera in the courtroom, and so I wanted you to be aware of that. This is the continued proceeding on what was originally set as an informal request to unseal documents. Initially, I want to give my apologies for counsel because on the date this court selected, I was not available. And I do apologize to you because I know you all did appear and I was not here. So thank you for your patience. Judge Moss was here. I understand when Judge Moss heard the proceedings in my absence, he did grant a further sealing order, allowing that the opposition to be sealed too. So I wanted to start with that. I did review all of the pleadings in this matter, being well aware of the initial filings because this court, in fact, signed both the original request and the original sealing order. I would note that that original sealing order had a time frame for it. It was not a sealing order that was intended to be in effect forever. In fact, the time frame set forth was very specific. The sealed document, and that was initially the unredacted pleading, the court having ordered some redactions, would become public after respondent's first appearance or after a permanent hearing was conducted. I understand the respondent has made a first appearance. Again, I'm aware of that. I've reviewed the respondent's appearance as well as the declarations filed in support of that appearance. I would also note I have not received any further request to seal other than the original request, the amended request, and the further request, which the court did grant in part, having ordered that 2 attachments be further sealed, the court having made all of the findings required under the rules of court. And that additional order also had the same time period, respondent's first appearance or after a permanent hearing. Now, I would note, I've looked at the timing in the matter, that my original order was entered on May 5th. The petition to amend, which was granted in part, was entered on May 6th. The request was then made to seal the entirety of the case. The court denied that request on May 10th. The response was filed on June 14th. And again, then I set this hearing on June 24th. I have not received any further requests to seal. And the rules of court are very clear that there must be a motion or application to seal documents before the court enters an order to seal. So, having reviewed all of the filings, as I noted, including the response, which included a declaration, and the declaration that was attached by one Mr. Lincoln included his home address, or at least some address. Frankly, I don't know whether it was a home address, but it included address. Also, respondent's response included his full name. the name that the court previously ordered redacted. I know from the opposition that there is an agreement that some of the matters in the court's order to seal should be unsealed, but others there is an argument for further sealing. My tentative ruling is to order the entirety of the case with the exception of a single attachment, the attachment showing the minor child, which I would find and make all of the rulings required under the rules of court should be sealed. The rest of it would be unsealed. That's my tentative. Now, again, in part, that's because much of this matter has already been put out by respondent himself. So, let me just ask what I see as the moving party. You'd be submitting to the court's tentative?
Sorry, are you saying that KFMB is the moving party, Your Honor?
Oh, I think that's right.
All right.
It's not the court. The court didn't make the motion on its own. It just set the matter for hearing because I got what I saw as an inappropriate ex parte communication.
I understand, Your Honor. So KFMB certainly appreciates Your Honor's thoughtful consideration of this issue. On the subject of the photograph of the minor, it would be KFMB's request that the court release that photo with the face of the minor redacted. And may I offer a short argument on that issue?
I'll take argument, but let me ask you this. What possible public interest could there have in any viewing of a minor, whether it's a face or the rest of them? We know it's a child. So what the child looks like, frankly, I'm missing what possible public interest there would be.
Yeah, well, so I guess I would refer Your Honor to Globe Newspaper Company v. Superior Court, and that's a case that we cited in our papers. The citation is 457 U.S. 596.
You need to slow down for the court reporter, please.
I apologize. The citation again is 457 U.S. 596. And in that case, Massachusetts had a blanket rule that required the exclusion of the public during the testimony of minor victims of sex offenses. And the U.S. Supreme Court concluded that a blanket rule of that nature could not stand because there needed to be a specific finding that in the specific facts of each case that the overriding interest in protecting the minor overcame the public's right of access. And so I understand that to be a determination that there is a public interest in all forms of evidence that are presented to the court, including evidence regarding minors. Now, certainly that interest can be overcome in certain circumstances. We think that an appropriate balance of the competing interests here could be achieved by redacting the face of the minor in order to allow the public to see what was presented to the court, which was evidently a picture of a minor near firearms. And the public, in addition to knowing what is in the picture, deserves to be able to see it for itself. The petitioner evidently thought that the photograph would be more compelling evidence than simply describing it. The petitioner could have just described the photograph in a declaration, but instead submitted the photograph as evidence. And we believe that the public now...
Let me ask you this, Mr. Hallgren. What if the court ordered everything redacted other than the minor's feet? Which shows you everything that I think you want to know, proximity to the firearms. Isn't that what the interest allegedly would be?
Yeah, I think that would be fine. If, in other words, not everything. You would redact the minor's body except for the minor's feet, but you would otherwise show the guns and other things. Yes, I think that would be fine.
Okay. All right, I assume that at least the police department opposes the request. I would note that I would not be ruling on Judge Moss's order. ordering the responsive brief to be sealed because I don't believe I could rule on that, and so I would allow that to remain sealed. But you have my tentative otherwise. I would note, although it is noted apparently that the respondent joins, I have no joinder and I have no brief from respondent. So let me hear from petitioner, and then Ms. Martinez on behalf of respondent. If there's something you want to tell me, I'll certainly listen to that.
Thank you, Your Honor. Can you hear me okay? This is my first sound test. Okay, very good. Perfect. I want to just say, I don't think counsel really answered the question on the public interest that would be served. And everything counsel cited in response to blocking out the face of the child in this picture is already achieved by the release of the other picture that has the entire table full of guns, absent only the child in that identical photograph.
Well, so let me ask you this. Hold on, Mr. Brooker, if I can ask you this, as I asked opposing counsel, the argument is the interest that is not in the first photograph is the proximity. And how do you show that without having some idea where the minor child is allegedly standing, or again, the proximity?
Well, I think proximity is described in the unredacted version of the declaration, where it says that there's a child standing on the table surrounded by approximately 16 firearms, passports, IDs, and various caches of ammo. So I think proximity is satisfied in the wording of the already released information, which also shows that, supports the compelling for the sealing of this portion of it, insofar that that's how it's narrowly tailored, with no lesser restrictive means to achieve the overriding interests of revealing the identity of the child, putting that child therefore at risk, which is outlined in my opposition papers.
All right, so let me ask you the same question, assuming for purposes of argument that I agreed largely with you on this one photograph. We're talking about attachment 2. On the other hand, understanding the argument about proximity, isn't the balancing required under the rules of court achieved if everything other than the child's feet are redacted, because the feet is the proximity, right?
Can I have a moment to review the declaration again, just so sure. I can make sure the description is absolutely accurate?
And I am looking at the photograph, which was sealed, and just so you know, I confirmed ahead of time that what I'm looking at is not viewable by the camera, and I wanted to confirm that because I knew I'd be pulling it up, so I have.
So the only proximity shortcoming I see in the wording of the declaration really amounts to the specificity of where on the table the child is standing with regard to proximity alone. And it does say surrounded. So since this is all going public anyway, why don't we just say that the child is standing in the center of the table as the picture depicts. Now it's out there. So now there's no proximity question at all to be had or to be sealed or not revealed to the public to achieve that interest.
All right.
Mr. Holton, does that satisfy you?
As we know, or at least as they say, a picture tells 1,000 words, right?
Yes, ma'am, it certainly does.
Okay. All right, go ahead. The remainder of your argument.
So the remainder of the argument has to do solely with the I'm in a catch-22, Your Honor. I have to be honest with the court. By revealing why the public interest would be overridden by the interest in sealing, I'd be revealing exactly what I'm sealing, which would, since this is being recorded, I can therefore not really go into why the public interest is overridden.
Except, let's put it this way. I have a response filed by at least one party that goes into much of this. that's not sealed, and I have respondents' response to the underlying petition that goes into much of what was sealed, which was not sealed again and is already part of the public domain.
Partially yes, but entirely no. So, I mean, if I'm forced to reveal my hand to the limited extent that I'm able to, I would say that, you know, I have information that there is an ongoing CWS investigation.
But excuse me, counsel, respondent said that in his response to the underlying petition. So he's already made that clear.
That's correct, Your Honor, but that's also incorrect insofar as that was a previous investigation that's already been closed. A new investigation has opened since then, and that's the investigation I'm referring to. And that's the investigation I would not want to compromise by revealing factual details of the children in their relation to the missing person case crossing into the GVR.
Let's look at the actual document and tell me which portions that I've ordered sealed that you believe would be somehow compromise anything if I ordered them unsealed, given what's already in the public domain.
I'm referring to page 2 of 3 in the declaration, the last full paragraph, the last line that starts with Chula Vista Police Department, with the remainder of it being redacted.
We're talking again, and you can give me a register of action number if that's easier. Which document are you talking about, the petition or the order or the declaration?
The declaration attached to the petition.
I believe it's ROA 14, if that is helpful to Your Honor.
Always, thank you. That's the petition. So I'm not certain that's it.
It's in the GV 100 in the section 7, and it's expounded on in the declaration at the point at which I just referenced prior to this.
Okay. All right. And let me ask you this. You don't believe any of that information is already in the public realm?
Not to the specificity that it outlines in that declaration. No, Your Honor, I do not believe it is. If I missed it, I'd be happy to be pointed out. I'm sure Mr. Hallgren, I'm sure Ms. Martinez might know where it's at, but I didn't see it when I did my look through.
Okay. Well, that's much more narrow than what you argued for in your papers.
It is, Your Honor.
All right.
And just so you know, Your Honor, to give you a little backdrop, Mr. Hallgren and I have been in constant communication in the last 3 or 4 days, and we did reach an accord on just about everything except, so essentially the San Diego Police Department and City Attorney's Office have agreed to release with Mr. Hallgren. We did not, we agreed that we would not put up a fight for any of the information regarding Mr. Millete, his missing wife, that there is an investigation, that he is a person of interest, and that we would concede everything that's already essentially in the public domain. The only issue...
Serial numbers, for example, are already there too.
Serial numbers are already where, Your Honor?
In the public domain. Respondent talked about in his responsive declaration?
I believe some of them are, not the entirety.
Okay.
And then, so the only issue that myself and Mr. Halgren did not come to terms on was the issue of the photograph of the child, which the court's already given a tentative and has entertained argument, and any of the references to the children in the declaration. And those are the reasons I outlined in my opposition papers that I still stand by now and would submit on, unless the court has any specific inquiries into those regards.
I don't, thank you. Ms. Martinez, is there anything you wanted to add? Again, I didn't see a joinder, or I did see that apparently you agree with the request to keep things sealed, but I don't have a motion to seal filed by anybody, and I don't have a joinder, but I'll hear from you.
Yes, thank you. Thank you, Your Honor. Thank you for the opportunity. Yes, because when we responded to the petition, I was under the belief that that was going to be sealed as well. I did not know that it was going to be released in the public domain, so I didn't ask for an additional protective order because of that. Because my understanding was there was a protective order. Then, so when we filed our response and declarations and other exhibits, we were under the belief that they were all protected. But since they are already out in the public now, and there's no way of retrieving them and protecting them in those specific areas that are discussed here, it seems to me that it's out there. So what other control do we have? Now, I am still under the belief, Your Honor, that a protective order protecting the minor child is so of vital importance here.
Hold on, Ms. Martinez, what protective order are you talking about?
Just the photograph, Your Honor. The sealing of this photograph with the child. I agree with your tentative, in other words, Your Honor. I don't want to belabor that because I heard your tentative. And so I feel safe that you feel the same way as I do. And that's my concern. I wanted the children protected. The child is there. I don't want any of that to be released in the public.
Right. And I agree. There's nothing to be gained by showing and viewing a child themselves, even the body, even the t-shirt or the shirt that they're wearing. And I agree with you. On the other hand, the police department is asking that references to the children continue to be sealed. And it looked to me like they were discussed, and I understand now inadvertently, but discussed in your response to the requested restraining order. Am I missing something?
No, Your Honor. No.
Okay.
I think we're on the same page.
Okay. And Mr. Brooker, again, can you clarify? I understand the dispute on the photograph, and I have both the sealed and the unsealed document in front of me. Can you point me specifically to the provision on the sealed document and do it in whatever manner you can without revealing the information, if you can, which specific portion we're talking about?
Yes, Your Honor. There's the GB100 has an attached declaration that's 3 or 4 pages. The title of that page is the MC031, page 2 of 3.
I'm there.
Okay, so you go to the last full paragraph that starts with "I was informed."
Okay, I'm there.
And you go 3 lines down. The line starts with "Chula Vista Police Detective."
All right, I have that.
Everything after that is redacted, correct? In your
It was previously, right. So that's
yeah.
what you'd be requesting.
That's to zero the court in on what I'm talking about. That's it.
Okay. Mr. Hallgren, again, as I see your client largely as the moving party, anything else you want to tell me?
So I, of course, don't know what the redacted line says. I understand it has something to do with Child Protective Services investigation. It seems unlikely to me that whatever is contained in that one line of text would be so damaging that it would overcome the very important public interest in knowing what evidence was submitted in support of this GVRO. And so KFMB would request that that line not be redacted.
All right, thank you. And again, I appreciate very much the argument today in the papers, and I am not, whatever I do today will not affect the order that Judge Moss made as to the response being sealed. That would remain sealed. However,
Your Honor?
Yes.
I'm sorry, with respect to Judge Moss's order, I understood it to be self-terminating. In other words, I understood it to be that if the court did not adopt the reasoning presented by the petitioner in his papers, then the papers would be unsealed automatically.
That's not what the order that I have says. I only have his order, and it orders the opposition to be sealed. So if in fact that was inadvertent, Judge Moss is available and he can correct it. He's in North County, but he's available. All right. I don't see that there was any order made as to a termination. And I don't know, frankly, that the document that was filed would have been filed unless there was the sealing order. So there may be some further request. Mr. Berker?
That's correct. I would not have filed it.
Yeah. So my thought is you could always bring a motion to amend the sealing order if you want, or to clarify or correct if it was entered inadvertently. But again, I am not going to touch that order. That would remain, and the response would remain sealed for the time being. I note, again, the rules of court are very specific. They say that unless confidentiality is required by law, court records are presumed to be open. The only way they could be sealed is if the court makes a finding of specific facts, and that is supposed to be made upon motion. I don't have a new motion. I have the original motion. I granted it, but I granted it with a time frame. That time frame has expired. I cannot make the facts that are otherwise required that the court make, including that there exists an overriding interest that overcomes the public access to the record, that the overriding interest supports sealing the record, a substantial probability exists that the overriding interest will be prejudiced if the record is not sealed, that the proposed sealing is narrowly tailored, and no less restrictive means exist to achieve the overriding interest, except as to the one attachment that is of the child. The court does make those findings as to the photograph of the child, but will order that that be unsealed to the extent that it may show where the child is standing on the table. I note and I agree that it was discussed in words, but words don't capture quite the position of the child. So that may be unredacted as to the child's feet only, which I believe will show the position of the child. The rest would remain redacted for the rest of the case, noting in particular that many of these facts are either part of the public realm anyway, based on apparently media's ability to find things out, or the fact that the respondent himself put it in his response of pleadings. I cannot make those findings. So again, the court finds that its sealing order has terminated and will not enter a further sealing order except as to the one attachment. I believe it's attachment 1, and that may be released only in redacted form. Any questions?
Yes, Your Honor. Oh, go ahead, Mr. Brooker.
Oh, thank you, Mr. Cochran. I just want to make a brief record, too, that on the court's comments, which I accept and receive, the Judge Moss instructed us to file points and authorities in response to the motion in support of continuing the seal. And that's what I filed on the judge's instruction.
And I understand that, but hold on. Again, Judge Moss came down and sat in my place on the day. It was set on the court's calendar. I know how it was set because I set it, but I'm not quite certain he knew how it was set. He just covered my calendar for me. So for the record, and to be complete, I received, again, what I viewed as an ex-parte communication asking to unseal, again, largely because my order would have ordered it already on its own, unsealed. So there was no specific motion pursuant to the rules of court. There was time for one, it wasn't received. So I understand what Judge Moss said. I have a guess too, though, why he said it. Okay, Mr. Holgren?
Yes, so just in terms of logistics, is the order that the petitioner submit a new copy of the photograph with the child's body redacted except for his feet, and that photograph be available through the clerk's office?
Let me ask Mr. Clerk if we can do it ourselves, as I'm ordering the remainder unsealed. And so I will ask Mr. Clerk what's easier for us.
I believe I can print it out and redact it.
We can do it ourselves, or if you want to both all take a look at it first and come up with an agreed upon version, you know what I would be ordering, and I have no problem with you doing it between yourselves. And it would have to come, though, from the police department, which has the unredacted version. So it's up to you. We can do it. I wouldn't unless you all agree.
It's fine with KFMB if the court is willing to do it. That seems the most easy to us.
Your thoughts, Mr. Brooker?
I guess I'd need to see it because there's a.
Well, then you do it. Then I'll have you do it. Okay, send it to Mr. Holgren and Ms. Martinez. I would assume you can come up with an agreed upon version and then submit it to the court. And I'll wait for that to order anything else unsealed. How's that?
Yes, Your Honor.
I'll have that to you, Mr. Holgren, by tomorrow, if that's okay.
That's fine. Thank you, Mr. Brooker. And may I raise one more question, Your Honor?
You may.
So I understand that it's common in these GVRO cases to issue these self-terminating sealing orders. And my client informs me that the clerk's office does not recognize those orders. And so anytime he wants to access these, he needs to go through this process. Is there some way that we can make that easier?
I understand the issue. Let's put it that way. I have been told about the issue. I am considering a better way to do this. And I know that. One of the things that the court is considering is to put a date, because certainly another court could then issue a further sealing order. And I usually know some sense of timing, at least when the hearing would be set. So that is something I am considering, but I understand the issue.
Thank you, Your Honor.
Okay.
That would be great.
Thank you.
All right. Again, thank you very much, and I appreciate the fact that I put you over once and you had to come back here again. I do appreciate that, and I'll look forward to the filing, Mr. Brooker.
Very good, Your Honor. Thank you so much.
Thank you all.
Thank you.
Thank you.
Bye-bye.